Next, call the case of 118914 in the matter and care of the treatment of Robert J. Sigler.
Apologize, Your Honor. I sensed that I was getting a little bit too dry while waiting, and
That's fine.
I didn't want to start coughing while at the podium.
I think we always have a little bit of a lapse ourselves as we shift from one case to another, so that's fine.
May I reserve 3 minutes for rebuttal?
You may.
And this is Kristen Patty appearing for appellant Robert Sigler. For the audience listening, there's one important fact that plays into both of the issues that Mr. Sigler has raised on appeal. And that is that when he was about to be released from prison in 2013, the state filed a petition against him to determine whether he was a sexually violent predator. And it proceeded to a bench trial in front of Judge Keeley in February 2015, and Judge Keeley determined that Mr. Sigler was not a sexually violent predator and released him on parole in June of 2015. About 7.5 months later, Mr. Sigler was determined to be in violation of his parole, and the state filed another petition to determine whether he was a sexually violent predator. This time, the case proceeded to a jury trial, and that jury did determine that Mr. Sigler was a sexually violent predator, and he was committed to the treatment unit at Martin. So the two issues that Mr. Sigler raises on appeal are, first, requires this court to provide further guidance under its 2009 decision in Sporn in just what qualifies as a material change in mental state in order to allow the state to exceed what has been considered to be the one proceeding authorization by statute. The second involves something that a psychologist said while on the stand about Mr. Sigler's first proceeding that was inaccurate. And because there was no objection by defense counsel whether there should have been a mistrial declared by the judge sua sponte. So the first issue, of course, if the court agrees with Mr. Sigler on that, means that he would be released. Since I did the brief in this about a year ago, there's been no further guidance provided by either Sporn or also by Turner, the California case that this court relied on in part in order to issue Sporn. There was the risk assessment provided by all four experts from the state, both from the first trial and the second trial, was basically the same. They all scored him a 4 on a test called the Static 99R, which, as the Court of Appeals reminded me, it's static, counselor, it doesn't change. And then there was also really no change in his psychological diagnosis. They all diagnosed him with some variation of pedophilia and an attraction to underage males. So really what's left is whether the fact that Mr. Sigler violated his parole by looking at sexually explicit websites or Instagram accounts on his phone, some might, they had males in various stages of undress, and some of the males might have been between the ages of 14 and 17, which would qualify as child pornography. Not that I don't think that was ever proven. All of that put together, whether that qualifies as a material change in circumstance in order to allow the state to exceed the one proceeding authorization and commence a second proceeding to determine whether Mr. Sigler was a sexually violent predator.
To be clear, Counselor, you're not saying that you get one proceeding per one conviction. You're not making that argument.
Well, this court has said pretty much you get one proceeding from one conviction, but certainly this court left the door open in Sporn for some circumstance to allow a second proceeding. And that's what this court needs to answer, is whether the facts of this case are enough. Certainly there would be some circumstance, Mr. Sigler would argue, that would have to be more extraordinary than this one to allow a second proceeding. But
So you're not making an absolute argument. That was the question.
not an absolute argument. Would like to, but I don't think that you've given me that leeway under Sporn. The second issue that Mr. Sigler raises in this appeal.
Well, let me get back to the first
Yes, sir.
issue. The allegations went to sexually explicit websites, did that kind of thing, and I assume a part of the trial evidence from the experts that those actions, doing those behaviors, demonstrated that he was engaging in dangerous behaviors, as opposed to just that demonstrated dangerous behavior.
Well,
Was that a part of the issue at the trial? Whether looking at sexually explicit material is demonstrating that he's different than what was produced before, and he's engaging in dangerous behavior.
Right. And, and I guess that's one of the things that Mr. Sporn did as well. He looked at internet websites, sexually explicit internet websites on his computer, and this court said.
Well, my question is,
that's
did
not
the experts tie that into that behavior demonstrates that he's a danger? That is taking a step towards his pedophilia diagnosis.
Well, and I think that's, in some ways, then that comes down to and then this is one of the things that I struggle with, Justice, because I certainly don't, I've got a problem here of trial counsel before me maybe didn't object to some things that I think he should have objected to. And whether this was actually child pornography, in my mind, wasn't proven. And so, but then I have the problem of what trial counsel objected to, right? Certainly, if he were looking at sexually explicit websites of clearly adult males, I don't know that we would consider that to be risky behavior, or women. But at least some of in the opinion of the parole officer who viewed, or the treatment provider who reviewed these Instagram accounts, they were at least very young-looking males. Whether they were above age of 18, no one really knows.
Can we? My problem with the pornography and the offense is that it doesn't seem like that was the launching pad for the second commitment proceeding, because what I'm reading out of all this is that additional element that Mr. Sigler had changed from a person who could control his behavior to a person who could not control his actions when released into the community. Now, let's start with just that allegation. Would you agree that if that allegation was proved, that would be enough to get you out from under res judicata and collateral estoppel in order to justify the second commitment proceeding?
Perhaps, but it ends up being a circular argument, doesn't it? I mean, we,
How is it circular? That's a new allegation. He has changed to a person who can't control himself in the community. Now, whatever the evidence is, it may,
Right.
it is. But just that allegation, if proven, ought to be able to pull the trigger on the second commitment proceeding, right?
I guess the problem is kind of often like an attempt analysis. Where do you make this a substantial step? And certainly he, viewing a pornographic website, is that a substantial step towards
Well,
not being
but
able
now
to
you're
control
arguing
yourself?
the evidence.
Right.
And I'm just saying we can agree, I'm just trying to figure out if we've got common agreement that we can trigger a second proceeding if we can prove this, that he can no longer control himself in the community.
I think that under Sporn, that might be considered a material change, yes.
And so it seems to me the way the state tried to prove that element was his reluctance or refusal to talk about his fantasies. So again, it's not the content of the dirty pictures he's looking at. It's that he's refusing to talk about his fantasies, and that's showing that he's not able to control things, as I'm reading this case. That seems to be legitimate evidence of our element that we agree can trigger a second commitment.
I guess looking at it potentially from Mr. Sigler's perspective, is it's almost one of those things if, you're darned if you do and you're darned if you don't. If you admit to having fantasies, well, is that going to land you into a second commitment proceeding? And so how far could he go and discuss a fantasy with a treatment provider and not risk basically building a case against himself for a second proceeding?
But
Well,
isn't that a
fantasy-
jury question?
But wouldn't a fantasy wouldn't have landed him in parole violation land, would it? The first thing had to happen was something that triggered him being back in custody, because that's a condition precedent, right? So there had to be a parole violation.
Which was the viewing the Instagram. Yeah.
Right. So the fantasy maybe would build on after that, but I guess I'm not finding that
Well, and
that concern real persuasive if you're going to participate fully in counseling, you're not going to get yourself in parole trouble. So
Are we missing the point here? It seems to me that the most fundamental question is how many times does the state get a shot at proving the elements? We had a district court that found 2 of the required elements didn't exist. And as you said, the Court of Appeals said static means static. So how many times does the state get to put together evidence and try to prove certain elements before it becomes res judicata?
and I guess that is the question that you're asked in this.
And I don't see that you provided an answer. Why isn't the decision by Judge Keeley entitled to deference and entitled to finality?
Well, actually, I think it is.
Well, but did you argue that?
Well, I guess I tried to, except that obviously this court, as I said, left open the door and Sporn for something. And just what that something is has not yet been decided. I don't think that he went far enough. And I guess to go back to Justice Lukert's point, normally in other types of, say, criminal actions, and this is kind of a quasi-criminal proceeding, you're not punished for your thoughts. So, but I could, as I said with Justice Biles, I can see a reluctance for someone to discuss a fantasy in a treatment setting just because you don't know. These things end up coming back up against it. And Justice Johnson, even to go back to your point, one of the problems that I have in this case is what my trial counsel did, and he did not object to the state introducing evidence that they did not use in the first trial. You can argue that they had a trial, they lost, and they figured out how to put a better case together the second time. I am technically out of time. I did not want to completely ignore the second issue, particularly if there were any questions from the court.
You have the 6404 problem.
You think I have a 6404 problem?
Well, there was no objection to
There-
the psychologist misstating the facts.
Exactly. And, when I addressed that in my preservation of issue for appeal, technically there's a 1988 case from this court that appears to be good law that would seem like at least the judge himself deciding to sua sponte declare a mistrial, that is still outside the purview of 6404.
For the judge, the trial judge.
The trial judge.
6404 applies on review.
Right.
So how do you extend that decision to what we can do?
Well, it was a Court of Appeals decision from 1988. It appears to mean good law. It said that 6404 applicable in that situation is non-controlling on a trial judge in determining whether to grant a mistrial. So, this is certainly one of those circumstances that is, in this case, we're arguing that this circumstance and what the psychologist said on the stand was so inflammatory, akin to a criminal jury being told that the defendant had been convicted before, that the judge should have declared a mistrial sua sponte. We acknowledged that there's a 2012 Court of Appeals decision where that court refused to consider a claim under similar circumstances because there was no objection. So I guess I'm kind of in a gray area about whether to get around 6404, which I tried to recognize. And it comes down to whether if you think an objection from defense counsel was important enough, whether it's of a degree that it obviously prevents an ineffective assistance of counsel proceeding, which he could pursue, I think, under 60-1501. And I don't know whether that adequately answers the question. Okay. I know I'm out of time. I'm trying to read faces and see if there are any other
further
questions.
questions.
Okay.
Thank you.
Thank you.
May it please the court, I'm Assistant Solicitor General Dwight Carswell, appearing on behalf of the state. The District Court and the Court of Appeals both correctly held that res judicata did not bar the commitment proceeding here. Res judicata only applies when two cases involve the same claim. Under the transactional test that this court has used when applying federal claim preclusion, and has suggested at least applies as a matter of state law as well, a claim is defined as involving a common nucleus of operative facts. In Sexually Violent Predator Act proceedings, the issue is on the offender's current mental status and dangerousness. And so, of course, as in Sporn, if the evidence of those two factors are the same in between the two proceedings, then res judicata would apply.
But Counselor, the issues that were decided adversely to the state were likely to commit repeat acts of sexual violence because of the mental abnormality or personality disorder. And second, that state didn't prove the serious difficulty controlling dangerous behaviors. So how is that those two issues were still in play in the latest proceeding, and they had been decided adversely to you, why does the state get another chance to try to prove that Judge Keeley was wrong?
Well, during the first commitment proceeding, the issue was decided whether he was dangerous at that time. Now, there's a material change of facts, as there was here. Res judicata does not apply. In a Sexually Violent Predator Act proceeding, as the court noted in Hendricks, the U.S. Supreme Court noted in Hendricks, the issue is an individual's current status. It's not frozen in time. So if an individual becomes more dangerous, then the state is authorized. Res judicata does not bar a second commitment proceeding. And that, again, as I said, that's what happened here. After being released following the first commitment proceeding, Sigler reviewed apparent child pornography. Now, the Court of Appeals, relying on Sporn, seemed to believe that that alone was not sufficient. The state disagrees with that, which is why we filed our conditional cross petition for review. We don't read Sporn as establishing a categorical rule. Rather, we think the inquiry has to be case specific. And I think there are at least three factors that...
May I ask a question
Absolutely.
before you continue with that? Sure. You said that res judicata would not bar if there are new facts or new circumstances, different claim.
Mm-hmm.
What about the statute? I mean, this is purely statutory, this whole action, right?
That's correct. In Sporn, this court in dicta did say that the statute seems to suggest that you can only have one commitment proceeding. That's not ultimately what the court held. The state disagrees with that for two reasons. One is Sporn went on to discuss that's part of the notice provision of the statute, which subsection F says that provision is not jurisdictional. It doesn't prevent the Attorney General from filing a commitment proceeding whenever the elements are met. And so Sporn actually at the end of that discussion said compliance with the provisions of KSA 59-29A03 is not necessary for an SVPA action. So that statute just doesn't, it's just a notice provision.
Did that statutory subsection get added when we had litigation over a 60-day time limit?
I believe,
I think that
or
was
at
the
least tweaked.
source. It was a time limit thing. Okay, and what was your second reason?
Sure, and then the second point, is if you look at the actual language of the statute, what we're talking about, it talks about anticipated release from total confinement. That's the language. Sporn seemed to read that as total confinement meant total sentence. Mm-hmm. We don't think that's a proper reading of the statute. If that were true, then the state couldn't commit someone initially being released. If they had completed their whole sentence, that would be an absurd interpretation of the statute. Total confinement here means essentially prison. When a person's released from prison to post-release supervision, they're no longer totally confined. So the statute itself seems to favor the state's position, naturally read, that whenever a person is released from prison, that triggers the ability to file an SVP action.
But it begins with the word one. And that seems to distinguish the language of our statute from some of the other state statutes that are just discussed in some of the cases you have cited. The language there is broader, that doesn't have the word one action. And how do you think these other reasons allow us to read around that word one?
I'm not sure what word one you're referring to.
I don't have it exactly in front of me, but as I recall, the statute begins with just that provision.
The language in question, which Sporn talked about, it's KSA-59-29A03A1.
Yes.
And it says, before an anticipated release from total confinement. And the state's view is that occurs whenever a person is released from being totally confined, or in other words, being released from prison. And so the statute doesn't bar a second commitment proceeding. The question then is whether res judicata does. And if the material facts are the same in both cases, it would. However, if there's been a change in material facts, then res judicata would not apply. As I was saying, Sporn, I don't think, establishes a categorical rule regarding the viewing of child pornography. I think there are three factors that have to be considered in a case-specific inquiry. The first is whether at the time of the initial commitment proceeding, there was evidence of viewing of pornography. If so, and that just continued, obviously there's no change. Here, however, there wasn't that evidence that while in prison, Sporn had been viewing pornography. That's something that only occurred after he was released. That was a change. Second is the age of the individuals depicted in the pornography. Here, Sporn said that he believed the boys were 14 to 17 years old, which that's kind of his target victim demographic. That's much more concerning than if it had been purely adult pornography. And then the third factor that I think is important is the frequency. If someone's really trying to control their behavior and, just on one occasion used pornography, that's something different. Here, Sporn said he was viewing it on a daily basis, which showed a complete lack of being able to control his behavior. So given those three factors, we think the viewing of apparent child pornography alone was sufficient to constitute a material change. But even beyond that, the Court of Appeals held that other factors, combined with those, established a material change. That was obviously correct in our view. As Justice Biles noted, the theory there was that while during the First Amendment proceeding, the evidence was he completed a sex offender treatment program in prison. He had a relapse prevention plan. He was going to be receiving sex offender treatment in the community. But once he got out, he showed that supervision just wasn't sufficient to keep him from controlling to allow him to control his dangerous behaviors. The treatment provider testified, this was Brandy Loudermilk, who said, we were giving him these tools to use, and he just wasn't able to show that he could apply those tools to control his behavior. He wasn't forthcoming with the treatment providers. Initially, when they found the Instagram account, he said, well, yeah, I did that, but I didn't view any other pornography. But then ultimately, he later admitted to pornography, but said, no, it was only adults, not children. Then he later admitted to he thought it was children. So he just wasn't cooperating with his supervision. He was ultimately terminated from that sex offender treatment program, in part because he continued to show high risk on an acute actuarial. This was the acute 2007, which unlike the static, which is static for the most part, the acute is a dynamic tool that measures risk within a specific time period. And here he showed moderate, and then that eventually became high risk right before he was terminated from sex offender treatment. So that combined with the viewing of apparent child pornography constitutes a material change. So res judicata should not apply.
Can we talk about the second issue a little bit?
Sure.
That was from your expert, the state's expert, Dr. Grimmel, who testified. I want to read it to you. This case is more dramatic than most because Sigler was actually civilly committed once, and then his commitment was overturned by an appeals court. And a lot of guys would have said, wow, that was a real shot across my bow. I better be careful on parole, but not Mr. Sigler. That was completely wrong. He was never civilly committed, never was a case overturned on appeal. And my question to you is, you're relying on this expert to prove your burden. Do you have any obligation to correct that gross mistake, that prejudicial mistake? What obligation do you have as the state's attorney, who I know you didn't prosecute it, but the prosecutor have in that instance? And I don't think it was cured by the cautionary instruction at all. So what do we do with that? Don't you have an obligation?
A couple points. First of all, I don't think it was prejudicial. The underlying point...
How is that not prejudicial?
Because the underlying point still remains valid, which is he had this first commitment proceeding. Now, granted, rather than being committed...
He was committed, and it was overturned by an appeals court, and that gave him a break, and he better be caught. That's completely different than what happened. Completely.
Well, it would be relevant for this official to make the same point about whether, if there was that first commitment proceeding as there was, and then he was found not to be a sexually violent predator. The point he was making is right after that happens, you'd think someone would try to control their behavior if they could. And here, immediately after being released, he started engaging in this behavior. So the difference between being committed and not being committed, we don't think is prejudicial. The underlying point remains the same.
Get my question. Do you have an obligation as a state's attorney who's using this expert to prove to meet your burden? Do you have any when that's something that I think flagrant occurs? Do you have any obligation at that point to correct anything?
Here, the state's attorney did make attempts to correct that. Before it happened, in the opening statements, the state's attorney as well as Sigler's attorney stated that during the first commitment proceeding was not successful. And then at closing arguments, the same points were made. That was also made in the instructions. The jury looking at all this couldn't have been under any misapprehension about what happened in the first proceedings. They were clearly instructed on that by all sides in the case. The judge, the state's attorney, and
But there is no kind of correction or just there's no cautionary structure that particular statement was wrong. Disregard the statement.
That's correct, yes. And in part because there was no objection. I'm sure if there had been an objection, there would have been. And so this isn't even properly before the court because there was no contemporaneous objection. But even if there had been, and I mean, I think at that point the district court would have instructed the jury, as he did in the final instructions. I believe that covers all of the state's points, unless the court has any other questions. And we would just urge you to affirm the district court and Court of Appeals. Thank you.
All right, thank you.
So I guess Justice Rosen, picking up on what you just asked the state, I would suggest that that is a flagrant enough circumstance in order to get around 6404. I really tried to outline it well in the brief with some criminal law cases from other jurisdictions. I think the state always has an obligation to see that justice is done, not just win their case. And sometimes that means when something's bad enough, maybe they need to even go up and ask for the judge for a sidebar. This jury deliberated for maybe 53 minutes. That's the amount that they were out. And today, being accused of being a sexually violent predator is the scarlet letter. It was really too inflammatory, and I think that's why we've argued that Judge Keeley should have declared a mistrial sua sponte, even though that there was no objection. And I guess there are no further questions for me? Okay.
There's a standard review on that issue, abuse of discretion.
It is abuse of discretion, but we argue, first of all, that there is an error, clearly an error of fact, because it was just not right, not even close. And then secondly, that Judge Keeley made an error of law because he failed to recognize the power that he had in that circumstance and apply the guidance that this court has given him.
What's the indication of that he failed to recognize anything? Maybe he just thought if you guys didn't object, it's not his place to throw a grenade in the middle of things.
Maybe that's true.
So I'm just saying there's no indication that he failed to recognize anything, right? He just didn't do it. We don't know why, because nobody asked.
We don't know why. I guess it's maybe because it was such an error of fact that was such a gross misstatement, and as Justice Rosen read the entire statement, it kind of went beyond just a word or two. He made it more inflammatory than needed to be. Dr. Grimmel did, and that way, it was difficult, I think, for Judge Keeley to overlook. But you're correct. He did not. We maybe don't know what went on in his mind.
Any further questions? Thank you, counsel.
Thank you.
We will take this matter under advisement.